Last minute technical issues. I didn't plug my computer in and the battery died on me. All right, a couple of things I wanted to go over and make sure that we're all on the same page, and that is we had a pretrial conference where the attorneys and I discussed one thing, and that is that my understanding that both sides have waived, or that the defendant has waived and the state has waived any requirement that the defendant, that the jury rather set the fine involved in the case. Is that correct?
That is correct.
All right. Second thing is that, where's my list of the three things? Awesome. Good. The second thing is that we agreed that it counts 11 and 12 of the indictment, that we are going to sever those counts for the record and have them considered by the jury after the conclusion of the initial trial. In other words, we're going to go through all of the trial process with all of the counts with the exception of 11 and 12, which, and the reason for that for the record has to do with the fact that those counts are including language. Sorry. Those counts are including language that involves a felon in possession of a handgun in the commission of a crime, and as a result of that, we're trying to avoid anything that might in some way influence the jury. So those two counts will be considered by the jury separately and apart than the first 10 counts after the conclusion of the jury's deliberations on counts 1 through 10. Once they reach their verdict, then we'll have another mini trial, so to speak, regarding 11 and 12 to ensure that there's no prejudice involved in having those considered. Now, the only other issue then is the swearing in of the additional jury officers. We have sworn in those that were present earlier, and we'll go ahead and bring in all of those who are jury officers that have not yet been sworn in. So they need to come in. All right, good afternoon, or good morning. We're going to go ahead and ask that each of you be sworn in, but before you do that, for the record, if you would each state your name and the agency of which you are a member so that the record is clear that you have been sworn in. Thank you.
Wayne Tipple, Tennessee Highway Patrol.
Andrew Perez, Tennessee Highway Patrol. Edward Dexter, Tennessee Highway Patrol.
Holly Melton, Dixon County Sheriff's Office.
Greg Howard, Dixon County Sheriff's Office.
David Elliott, Dixon County Sheriff's Office.
All right, and I'm going to ask you each to raise your right hand and be placed under oath by the clerk.
Do you solemnly swear to take charge of this jury, keep them separate and apart from all persons, not converse with them about the matters on trial, nor permit anyone else to do so, and return them again in open court on orders of the court, so help you God?
I do.
All right, thank you. Again, I appreciate the Highway Patrol's cooperation in this so that it eliminates some issues for us regarding that matter. But I would also urge you to make sure that the jurors are safe and comfortable and kept apart from anyone, and that no one attempts to influence them. So thank you. With that, we will go ahead and ask you to step out and resume your duties. Thank you. All right, anything then further before we bring the jury in and swear the jury?
No, Your Honor.
All right, we are ready for the jury. Oh, let me, hold on just a second, please. Ladies and gentlemen, there are media that are here in the courtroom, and I want to address them for just a moment. This is a public proceeding, and I don't want to interfere with you doing your job, but by the same token, there is a certain requirement that we do require for the media guidelines, so to speak. There was a pool request or a request for a video camera that was submitted by one of the stations, and that first come, first served is who has been allowed to have the pool camera, but any video that will be taken by the one video camera. The reason for that is to minimize the distractions that might be taking place if we had multiple cameras in the courtroom. If there were two media requests that, and who were they?
Well, there's two papers and one radio station request.
The court we can allow 2 still photographers under the Supreme Court's rules. And that would be on a first come, first.
Tennessee Dixon Herald,
The Dixon Herald and who else?
WDKN asked to take still photography with her camera.
All right. Anybody have any objection as long as it's done in a way that does not interfere with the proceeding?
No objection, Your Honor, as long as it doesn't.
All right. Whoever the media is, just as long as there's photography that does not show the jurors and is not distracting in any way, we'll be watching to make sure that doesn't occur. Then we'll allow those photographs to be taken. Anything else then before we bring the jury in? All right, we're ready for the jury. And while the jury's coming in, I have informed them they are permitted but not required to wear facial coverings at any point during this proceeding. They're welcome to do so. They may change their mind about it once they see the configuration of the jury box, but other than that, it's entirely their decision. We have a little bit of copies. Ladies and gentlemen, welcome to Circuit Court Room number 5. I think this one is, in the Dixon County Justice Center. Thank you for your cooperation. At this point in time, we're going to go ahead and have you placed under oath for your obligations as a juror. So if you'll all stand, please, and let the clerk administer the oath.
Raise your right hand. Do you solemnly swear that you will well and truly try the issues joined wherein the state of Tennessee is the plaintiff and Stephen Joshua Wiggins is the defendant, and a true and just verdict rendered according to the law and evidence, so help you God?
Yes.
Thank you.
And you've given a copy of this to the council. We're going to give, there's 16, there should be one for each of them. Ladies and gentlemen, as I explained to you a moment ago, this is a fairly lengthy 18-page document I'm about to read to you. Rather than just assume you can hang on my every word and understand it, we're going to give you a copy of your own so that you can read along with me, and that way you will be able to better understand everything. So this will be yours for the future if you can keep it with you, or you can discard it however you wish. Everyone have their copy? All right, if you'll read along with me, please. Ladies and gentlemen of the jury, the defendant, Stephen Joshua Wiggins, is charged in count 1 in the indictment with the crime of false report. In count 2 in the indictment, the defendant is charged with premeditated first-degree murder. In count 3 in the indictment, the defendant is charged with first-degree murder in the perpetration of a felony. In counts 4 and 5 in the indictment, the defendant is charged with theft of property. In counts 6 and 7 in the indictment, the defendant is charged with criminal impersonation of law enforcement. In count 8 in the indictment, the defendant is charged with tampering with evidence. In count 9 in the indictment, the defendant is charged with arson. In count 10 in the indictment, the defendant is charged with abuse of a corpse. The defendant pleads not guilty to all of the offenses embraced in the indictment. Before we begin the trial, I would like to tell you a little bit about what will happen during the course of the proceedings. I want to describe basically how the trial will be conducted and what the attorneys, jurors, and judge will be doing over the course of the trial. At the end of the trial, I will give you more detailed instructions on how you're to go about reaching your decision. But now I simply want to explain how the trial will proceed. The law applicable to this case is stated in these instructions and those that follow, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another or others, but should consider each one in the light of and in harmony with the others. The defendant has been charged by the state of Tennessee with a violation of state law. The document containing the charges is referred to as an indictment. An indictment is the formal accusation charging a defendant with a crime and is not evidence of anything. The defendant is charged in count 1 in the indictment with false report. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant knowingly made a false statement in response to a legitimate inquiry by a law enforcement officer concerning a material fact about an offense within the officer's concern, and with the intent to obstruct or hinder the officer from apprehending the person suspected of committing an offense. The defendant is charged in count 2 in the indictment with premeditated first-degree murder. The state must prove beyond a reasonable doubt that the defendant unlawfully killed the alleged victim, Sergeant Daniel Scott Baker, that the killing was intentional, and that the killing was premeditated. The defendant is charged in count 3 in the indictment with first-degree murder and perpetration of a felony. The state must prove beyond a reasonable doubt that the defendant unlawfully killed the alleged victim, Sergeant Daniel Scott Baker, that the killing was committed in the perpetration of or attempt to perpetrate the alleged theft of property, and that the killing was closely connected to the alleged theft of property and was not a separate, distinct, and independent event, and that the defendant intended to commit the alleged theft of property. If you find from the proof beyond a reasonable doubt that the defendant is guilty of murder in the first degree in either count 2 or count 3, then it shall be your duty, after a separate sentencing hearing, to determine whether the defendant will be sentenced to death, life in prison, without the possibility of parole, or life in prison. But you will not consider punishment for this offense at this time. The defendant is charged in counts 4 and 5 in the indictment with theft of property. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant intentionally deprived and knowingly obtained control over property owned by the Dickson County Sheriff's Office and Sergeant Daniel Scott Baker without effective consent. The defendant is charged in counts 6 and 7 in the indictment with criminal impersonation of law enforcement. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant intentionally and knowingly pretended to be a law enforcement officer for the purpose of engaging in an activity that is ordinarily and customarily an activity established by law as a law enforcement activity for the purpose of causing another to believe the person was a law enforcement officer. The defendant is charged in count 8 in the indictment with tampering with evidence. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant knew an investigation was in progress and destroyed or altered evidence with the intent to impair availability in the investigation. The defendant is charged in count 9 in the indictment with arson. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant intentionally and knowingly damaged personal property by fire without consent and to destroy for an unlawful purpose. The defendant is charged in count 10 in the indictment with abuse of a corpse. For you to find the defendant guilty, the state must have proven beyond a reasonable doubt that the defendant knowingly did physically mistreat a corpse in a manner offensive to the sensibilities of an ordinary person without legal privilege. The defendant has pled not guilty to the charges in the indictment. He is presumed innocent and may not be found guilty by you unless, after hearing all of the evidence, attorneys' arguments, and instructions of law, the 12 jurors seated in this case unanimously find that the state has proven its case beyond a reasonable doubt. The first step in the trial will be the attorney's opening statements. The state will tell you about the evidence it intends to present so that you will have an idea of what the state's case is about. This opening statement is not evidence. Its only purpose is to help you understand what the evidence will be and what the state will attempt to prove. After the state's opening statement, an attorney for the defendant may make an opening statement if they should so choose. Again, statements of the attorneys are not evidence. Next will be the state's case in chief, in which the state will present its evidence. The evidence in the case will most likely consist of physical exhibits, documents, and the testimony of witnesses. The witnesses will testify by answering questions asked by the attorneys. Venue of the offense lies in the county where the offense was commenced or consummated. If you find that the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dickson County, Tennessee, then you must return a verdict of not guilty. After the state completes its case in chief, the defense will be given an opportunity to present evidence through witnesses and exhibits. A defendant is not required to put on any evidence or to testify. The burden is always on the state to convince you that the defendant is guilty beyond a reasonable doubt. If the defense does present proof, the state may then put on what is known as rebuttal proof. After the state's rebuttal, the defense may put on further proof. After you have heard all of the evidence, the state and the defense may present final arguments. I previously told you that opening statements by the attorneys are not evidence. Likewise, closing arguments are not evidence. In closing arguments, the parties will attempt to summarize their cases and to help you understand the evidence that was presented. The final part of the trial occurs when I instruct you about the rules of law that you are to use in reaching your verdict. After you hear my instructions, the final 12 jurors will leave the courtroom together as a group. You will then begin your deliberations to make a decision in the case. Your deliberations will be secret, and you will not be required to explain your verdict to anyone. Now that I have described in outline form the trial itself, let me explain the functions that you and I will perform during the trial. I will decide which rules of law apply to the case. My decisions will be reflected in my responses to questions and objections the attorneys raised during the trial, as well as in my final jury instructions. It is your job to determine what the facts are from the evidence. You must then apply the law and my instructions to the facts, and from that application you will arrive at a verdict. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden remains on the state throughout the entire case. Keep in mind that the defendant is presumed to be innocent of the charges against him. Thus, the defendant is not required to prove his innocence or to have his attorney make any statements or arguments or to produce any evidence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the offense. You, as jurors, must decide whether the state has proven beyond a reasonable doubt that the defendant has committed the crime charged in the indictment. You must base that decision only on the evidence in the case and my instructions about the law. Witnesses will testify in response to questions from attorneys. Witnesses are first asked questions by the party who calls the witness to testify, then the other side is permitted to cross-examine the witnesses. Although evidence is presented by asking questions, the questions themselves are not evidence. An insinuation contained in a question is not evidence. You should consider a question only as it gives meaning to a witness's answer. In addition, members of the jury may ask questions of the witness if desired. The procedure for a juror to ask a question of a witness is that the question must be written down and submitted to me. Do not put your name on the question, as the questions of the jury are required to be anonymous. If a juror has a question that he or she would like to have asked of a witness, that question must be submitted in writing while the witness remains on the witness stand. At the end of the witness's testimony, the jury will be excused, and I will consider the questions of the jury on the record. Then the jury will return to the courtroom. If the question is allowed by the rules of evidence, the question will be asked either by me or by one of the lawyers. You should not place any significance upon the fact that I asked the question of the witness or whether one of the lawyers asked the question. In either event, the question is being asked of the witness solely because it was desired by a juror. The wording of the question may be altered by me, or the question may not be asked at all. If the question is altered by me, You must assume that I had a valid legal reason for altering it, and you should place no significance upon this fact, nor should you draw any inference from it. I may refuse to ask the question at all. In that case, you likewise should place no significance upon this fact, nor should you draw any inference from it. An important part of your job will be making judgments about the testimony of the witnesses who testify. You should decide whether you believe what each person says and the importance of his or her testimony. In making that decision, I suggest that you ask yourself a few questions. First, did the person impress you as honest? Second, did he or she have any particular reason not to tell the truth? Third, did he or she have any personal interest in the outcome of the case? Fourth, did the witness have any motive, bias, or prejudice that would influence the witness's testimony? Fifth, did the witness seem to have a memory of the events he or she testified about? Sixth, did the witness have the opportunity and ability to observe accurately the things he or she testified about? Seventh, did he or she appear to understand the questions clearly and answer them directly? Eighth, was the witness distracted in any way? Ninth, how did the witness look and act while testifying? 10th, was the witness making an honest effort to tell the truth, or did the witness evade questions? And 11th, did a witness's testimony differ from the testimony of other witnesses? Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, or improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. When a witness is thus impeached, the jury has the right to disregard his or her evidence and treat it as untrue, except where it is corroborated by other credible testimony or by the facts and circumstances proved on the trial. As the sole judges of the facts, you must determine which of the witness's testimony you accept, what weight you attach to it, and what inferences you will draw from it. The law does not, however, require you to accept all of the evidence. In deciding what evidence you will accept, you must make your own evaluation of the testimony given by each of the witnesses and determine the weight you will give to that testimony. You must decide which witnesses you believe and how important you think their testimony is. You are not required to accept or reject everything a witness says. You are free to believe all, none, or part of any person's testimony. In deciding what testimony you believe, you should rely on your own common sense and everyday experience. There is no fixed set of rules you use in deciding whether you believe a witness. In making up your mind and reaching a verdict, do not base any decisions on the fact that there are more witnesses on one side than on the other. Likewise, do not reach a conclusion on a particular point just because more witnesses testified for one side on that point. Your job is to think about the testimony of each witness you heard and decide the facts. At times during the trial, an attorney may make an objection to a question that is asked by another attorney or to an answer that a witness gives. This simply means that the attorney is requesting that I make a decision on a particular rule of law. Do not draw any conclusion from the fact that an objection was made or from my ruling on that objection. My rulings only relate to the legal questions that I must determine and should not influence your thinking. If I sustain an objection to a question, the witness will not be permitted to answer the question. Do not attempt to guess what the answer might have been had the witness been permitted to give it. Similarly, if I tell you not to consider a particular statement that was made, you should put that statement out of your mind, and you may not refer to it refer to that statement in your later deliberations. In deciding this case, you may not draw any inference from an unanswered question, and you may not consider testimony that you're instructed to disregard. Any arguments about objections or motions are usually required to be made by the attorneys out of the hearing of the jury. Information may be excluded because it is not legally admissible. Excluded information cannot be considered in reaching your decision. A ruling that is made on an objection or motion will be based solely upon the law. You must not infer from a ruling that I hold any view or opinion for or against any party in this lawsuit. Some of you have probably heard the term circumstantial evidence and direct evidence. These are the two basic types of evidence that exist in law. Direct evidence is direct proof of a fact, such as the testimony of an eyewitness. Direct evidence is those parts of the testimony admitted in court which referred to what happened and was testified to by witnesses who saw, heard, or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw, heard, or otherwise sensed, they presented direct evidence. Circumstantial evidence is all of the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all of the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. The court will not provide you with a transcript of the testimony at the end of the trial. Therefore, you must listen very carefully to the testimony. Each of you will be allowed to take notes during the trial for your own use during your deliberations. You are not required to take notes. Independent memory can be as accurate as written notes. You will be provided with paper and pen if you decide to take notes. During the course of the trial, you should not talk with any witness, defendant, or attorney involved in this case. Please do not talk with them about any subject whatsoever. You may see them in the hallway or on an elevator or at some other location. If you do, perhaps the best standing rule is not to say anything. Do not permit any other person to discuss the case in your presence. If anyone does attempt to do so, report this fact to the court immediately without discussing the incident with any of the other jurors. You should also not discuss this case among yourselves until I instruct you on the law and you start deliberating at the end of the case. It is important that you wait until all of the evidence is received and you have heard all of my instructions on the rules of law before you deliberate among yourselves. You must not communicate with or provide any information, photographs, or video to anyone by any means about this case. You must not use any electronic device or media such as a telephone, cell phone, smartphone, or computer, the internet, any text or instant messaging service, any chat room, blog, or website such as Facebook, MySpace, LinkedIn, YouTube, Instagram, Snapchat, or Twitter to communicate with anyone or to conduct any research about this case. During the course of the trial, there will be media reports in the newspapers or on TV or on the radio about this particular case. If there are, you are not permitted to read, watch, or listen to those reports. You as jurors must base your decision solely on the evidence you hear in the courtroom. You will receive all of the evidence you may properly consider to decide the case. Because of this, you should not attempt to do any research on your own or gather any information on your own that you think might be helpful. Do not conduct your own private investigation into this case, although you may be tempted to do so. Do not read any textbooks or articles concerning any issue in the case, or consult any other source of information. If you were to do that, you would be getting information that is not evidence. You must decide this case only on the evidence and law presented to you during the trial. Any juror who receives any information about this case other than that presented at trial must notify the court immediately. There are several rules concerning your conduct during the trial and during recesses that you should keep in mind. You will be a sequestered jury. You will not be allowed to communicate with anyone other than your fellow jurors and your sworn jury guards during the entire time that you serve on this jury. You will be kept together as a jury and separated from everyone else. You must not be outside the presence or supervision of your jury guards at any time. You must not speak to anyone other than your fellow jurors or guards at any time about any subject whatsoever. Second, do not discuss the case among yourselves during the trial. You must keep an open mind until you have heard all of the evidence, the attorney's closing arguments, and my final instructions concerning the law. Any discussions before the conclusion of this case would be premature and improper. Third, obey all instructions from your jury guards. They have been thoroughly instructed as to the proper procedure that must be followed. If they ask you to do something, there is a reason for it. Finally, during the course of the trial, I may have to interrupt the proceedings to confer with the attorneys about the rules of law that should apply. In some cases, we may have bench conferences in the courtroom outside of your hearing. And in some instances, I may ask you to retire to the jury room while we discuss a matter out of your presence. I will try to avoid as many of these interruptions as possible. We will try to resolve some of these things in the morning before we get started. I ask your patience because these interruptions are necessary points in the trial where we are to resolve legal issues. In the long run, they save time for all of us. If anyone needs a break at any time, please do not hesitate to ask. Simply raise your hand. If I do not see you, get the attention of one of your bailiffs who will advise me that a juror needs a break. Normally, I'll try to conclude the testimony of a witness before taking a break. The usual break times are at 10:30 in the morning and 2:30 in the afternoon, with the normal hour between 12 and 1 for lunch. If you need a break for any other time, please ask. A juror who is distracted is not paying full attention to the testimony. Both parties are entitled to your full, undivided attention to this case. This completes my opening comments to you. The next phase of the trial is the formal reading to you of the indictment in this case. This is the second day of August 2021. David Wolf, Circuit Judge. General Crouch, you may read the indictment.
The grand jurors of Dickson County, Tennessee, duly impaneled, sworn upon their oaths, do present that on or about May 30th, 2018, in Dickson County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully make a false statement in response to a legitimate inquiry by Sergeant Daniel Scott Baker, a law enforcement officer. Stephen Joshua Wiggins provided Sergeant Daniel Scott Baker with a false Social Security number to prevent his apprehension for outstanding violations, arrest warrants in violation of TCA 39-16-502 and against the peace and dignity of the state of Tennessee. Count 2, the grand jurors of Dickson County, Tennessee, duly impaneled and sworn upon their oaths, present that on or about May 30th, 2018, in Dickson County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully, intentionally, and with premeditation kill Sergeant Daniel Scott Baker of the Dickson County Sheriff's Office in violation of TCA 39-13-202 against the peace and dignity of the state of Tennessee. Count 3, the grand jurors of Dickson County, Tennessee, duly impaneled and sworn upon their oaths, present that on or about May 30th, 2018, in Dickson County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully, feloniously kill Sergeant Daniel Scott Baker in the perpetration or attempt to perpetrate a theft in violation of TCA 39-13-202 and against the peace and dignity of the state of Tennessee. Count 4, the grand jurors of Dickson County, Tennessee, duly impaneled and sworn upon their oaths, do present that on or about May 30th, 2018, in Dickson County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully, with the intent to deprive and without consent, obtain or exercise control over Sergeant Daniel Scott Baker's patrol vehicle number 500, a Ford Explorer police cruiser, property of the Dickson County Sheriff's Office, and said property being valued more than $10,000 but less than $60,000 in violation of Tennessee Code Annotated 39-14-103 and against the peace and dignity of the state of Tennessee. Count 5, the grand jurors of Dickson County, Tennessee, duly impaneled and sworn upon their oaths, do present that on or about May 30th, 2018, in Dickson County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did knowingly, with the intent to deprive and without consent, obtain and exercise control over the property of Sergeant Daniel Scott Baker, to wit, Sergeant Daniel Scott Baker's service weapon, a Glock 17 handgun, Sergeant Daniel Scott Baker's backup weapon, a Glock 33 handgun, and ammunition, said property having a value of over $1,000 but less than $2,500 in violation of TCA 39-14-103 and against the peace and dignity of the state of Tennessee. Count 6, the grand jurors of Dickson County, Tennessee, duly impaneled and sworn upon their oaths, do present that on or about May 30th, 2018, in Dickson County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully and knowingly pretend to be a law enforcement officer for the purpose of engaging in an activity that is ordinarily and customarily an activity established by law as a law enforcement activity, and causing another to believe that the person is a law enforcement officer. Stephen Joshua Wiggins made a radio transmission from Sergeant Daniel Scott Baker's patrol vehicle number 500 in response to a radio transmission from Dixon County Dispatch in violation of TCA 3916-301B12 and against the peace and dignity of the state of Tennessee. Count 7. The grand jurors of Dixon County, Tennessee, duly impaneled and sworn upon their oaths, do present that on or about May 30th, 2018, in Dixon County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully and knowingly pretend to be a law enforcement officer for the purpose of engaging in an activity that is ordinarily and customarily an activity established by law as a law enforcement activity and causing another to believe that the person is a law enforcement officer. Stephen Joshua Wiggins answered a cellular telephone call from Deputy Chris Lashley, Dixon County Sheriff's Office, while using Sergeant Daniel Scott Baker's agency-issued cellular telephone, and did pretend to be Daniel Scott Baker in violation of TCA 3916-301B12 and against the peace and dignity of the state of Tennessee. Count 8. The grand jurors of Dixon County, Tennessee, duly impaneled and sworn upon their oaths, do present that on or about May 30th, 2018, in Dixon County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully, feloniously, knowing that an investigation is in progress, did destroy and conceal evidence with the intent to impair availability as evidence in the investigation by setting fire to Sergeant Daniel Scott Baker's patrol vehicle 500, a Ford Explorer police cruiser, property of the Dixon County Sheriff's Office, in violation of TCA 3916-503, and against the peace and dignity of the state of Tennessee. Count 9. The grand jurors of Dixon County, duly impaneled and sworn upon their oaths, do present that on or about May 30th, 2018, in Dixon County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully, feloniously, and knowingly set fire to Sergeant Daniel Scott Baker's patrol vehicle 500, a Ford Explorer police cruiser, an automobile, property of the Dixon County Sheriff's Office, with the intent to destroy or damage said property in violation of TCA 3914-303, and against the peace and dignity of the state of Tennessee. Count 10. The grand jurors of Dixon County, Tennessee, duly impaneled and sworn upon their oaths, do present that on or about May 30th, 2018, in Dixon County, Tennessee, and prior to the finding of this presentment, Stephen Joshua Wiggins then and there did unlawfully, knowingly, and feloniously, without legal privilege, physically mistreated the body of Sergeant Daniel Scott Baker, a corpse, in a manner offensive to the sensibility of an ordinary person by means of setting the corpse on fire, in violation of TCA 3917-312, and against the peace and dignity of the state of Tennessee.
To that indictment, how does the defendant plead?
Your Honor, Mr. Wiggins pleads not guilty.
All right, not guilty has been entered. Then, does the state wish to make an opening statement? You may. Does this need to be on or off? All right. That's fine. Mr. Crouch, if the state wishes to make an opening statement, now would be the time. Ms. Lewis. This is your charge.
Shots fired, officer down. You will hear and see those were the last words ever spoken by Sergeant Daniel Scott Baker. I want to tell you how we got there, and this is what the state intends to prove. On May the 29th of 2018, the defendant was staying at a hotel in Kingston Springs, Tennessee, with his girlfriend, Erica Castro Miles. On that date, there was an incident, and the defendant stole the vehicle belonging to Erica Castro Miles. He left the hotel, and police responded. There was a BOLO put out by the Kingston Springs Police Department, Cheatham County Sheriff's Office, for the arrest of the defendant for theft of a vehicle. At some point on May the 29th of 2018, the defendant circled back to the Midtown Inn and Suites in Kingston Springs and picked up his girlfriend, Erica Castro Miles. He, the defendant, and Erica Castro Miles, for the next 24 hours, were driving around Dixon County, went to various locations, but ultimately, in the early morning hours of May the 30th, their vehicle became inoperable, primarily due to a flat tire. You will see the vehicle was parked, and they stayed inside the vehicle at the intersection of Tidwell Switch Road and Sam Vineyard Road in Dixon County. Now, at about 6:20 a.m. on May the 30th of 2018, a citizen resident of Dixon County called into Dixon County Dispatch to report a suspicious vehicle. Okay? Sergeant Baker, you will see, was just about to come on shift, as he was the shift sergeant, and he responded to that dispatch call. When he arrived at the intersection of Tidwell Switch Road and Sam Vineyard Road in Dixon County, he saw a 1998 Saturn with two occupants, the defendant behind the driver's side, behind the wheel, and Erica Castro Miles on the passenger side. Sergeant Baker performed a standard encounter upon such a request as a suspicious vehicle. He approached the driver's side window and asked the defendant for his name and proof of identification. He also asked the passenger for name and proof of identification. The defendant did not provide his name, his correct name. He provided a wrong name. He also provided a false Social Security number that you will see in the proof. At that point in time, Sergeant Baker, in a routine traffic encounter like this, called in the license plate number of the vehicle, Boy Robert Young 013. And Sergeant Baker had maneuvered himself from the driver's side window to the rear of the vehicle so that he could see the license plate. As he was waiting on a response, there was kind of some downtime in the car, just a few moments or seconds. And you will notice that the humidity and fog of that spring morning had glazed over the windows. They were hard to see into. At some point, dispatch radioed back to Sergeant Baker, informing him that Boy Robert Young 013 was a vehicle that had been reported stolen, which alerted Sergeant Baker that there could be a problem, or this could be someone who's in possession of a stolen vehicle. At that time, Sergeant Baker approached the driver's side window again, and he ordered the defendant to get out of the car because he wanted to do a further investigation to see what was going on. The defendant said, "I can't get out, this door won't open." The defendant continued to tell Sergeant Baker that the door will not open. The door won't open. That I have to have pliers on the inside of the car to open the door to get out. You will see this on Sergeant Baker's body camera. You will then see that Sergeant Baker said, "Okay, I'm going to walk around to the other side." As he was walking around the rear of the vehicle, going towards the passenger side, the defendant removed a .45 caliber high-point semi-automatic pistol. As Sergeant Baker approached the passenger side window, which had been rolled down, the defendant leveled off and shot through the passenger side window. Sergeant Baker ran backwards from the car and issued his final words, a warning. "Shots fired, officer down." Sergeant Baker collapsed on the ground, still alive. The defendant exits the vehicle out of the driver's side window, which he had previously said was broken. He approaches Sergeant Baker and at close range executes him. This is on video. The defendant immediately takes possession of Sergeant Baker's patrol unit 500. We will refer to it as Unit 500. He moves the car near Sergeant Baker's body. He opens the rear driver's side door, loads Sergeant Baker's body into the vehicle. Now the passenger, Eric Castro Niles, runs away from the scene. She is not a part of this trial. This trial is State versus Wiggins. He loads Sergeant Baker's body in. He begins driving away from the scene. At which point, the defendant, pretending to be law enforcement, answers multiple radio calls from Dixon County Central Dispatch. He's thinking clearly and quickly, and he responds, 10-4, one in custody, en route, Dixon County Central. Other law enforcement officers on that shift overheard some concerning radio traffic. They also heard a voice that they did not recognize to be Sergeant Baker's. So they began calling on the radio and cell phone. As the defendant was driving away with Sergeant Baker's body in the rear of the vehicle, the defendant answered Sergeant Baker's cell phone, a call from Deputy Chris Lashley. And he tells Chris Lashley, pretending to be Sergeant Baker, 10-4, everything's okay. You will then see that the defendant drives to the Bear Creek Valley area of Dixon County, Tennessee. He exits the roadway and he drives through a couple of fields to a remote area that can't be seen from the road. He gets out of the vehicle. He steals Sergeant Baker's backup weapon, which is his personal weapon, a Glock 357, and a knife belonging to Sergeant Baker. He takes Sergeant Baker's duty weapon, a Glock 9mm, pops the hood, puts that weapon, whether intentionally or by accident, we don't know, leaves that weapon under the hood of the vehicle. The defendant then sets fire to Sergeant Baker and also the front seat of the car. He closes the doors, locks the doors, and flees. Ladies and gentlemen, you will see proof that after fleeing the scene, one of the largest manhunts in the state of Tennessee occurred. And for a little over 2 days, the defendant was at large. But he was captured and arrested. And when he was arrested, he was found in possession of the murder weapon, a .45 caliber, semi-automatic high point, which was ballistically, scientifically confirmed to be the murder weapon. He was also found in possession of Sergeant Baker's backup weapon, the Glock 357, and Sergeant Baker's knife. Upon his arrest, he was taken into custody, but first taken to the hospital and checked out, where the doctors found that he was just dehydrated. After he was rehydrated, he voluntarily interviewed and provided a statement to the TBI, which you will hear and see. In that statement, he was asked, "Why did you walk up and shoot Sergeant Baker in the head at close range?" And the defendant said, "It's like a dog. You don't let it suffer." Ladies and gentlemen, this crime is on camera. The defendant has confessed. There's scientific testing, fingerprints, DNA, ballistic testings, all to confirm and reconfirm that the defendant committed these crimes. You will also see a video test by the TBI of the Saturn, where they demonstrate that the driver's side door is fully operational from the inside and out. The state's proof will show that the defendant was lying when he said the door won't open. The state's proof will show that the defendant set up Sergeant Baker forced him to go to the passenger side where the defendant could get a tactical advantage and await the moment to shoot him while he was unsuspecting. Not only that, ladies and gentlemen, you're going to hear from a witness in this case that earlier in the month of May, the defendant said, "If I'm stopped by law enforcement, I will smoke their ass." At the conclusion of the state's proof, I'm going to come to you and ask you to find the defendant guilty of every single count, because this case was proven not only beyond a reasonable doubt, but beyond all doubt.
Evans, you wish to make an opening statement?
Good morning. This is going to be difficult for all of you. There's no question that on May 30th, 2018, Stephen Wiggins killed Sergeant Daniel Baker. And he did so without excuse and without justification. You're going to be able to see from the vantage point of Sergeant Daniel Baker what transpired at Tidal Switch that morning. You're going to be able to see Sergeant Baker approach that vehicle. You're going to see Stephen Wiggins and hear him feign that the door won't open. You're going to be able to see Sergeant Baker walk around the vehicle. And you're going to see things escalate between Sergeant Baker and the vehicle when Mr. Wiggins doesn't immediately get out of the car, because he won't follow the instructions. And then you're going to see Sergeant Baker traveling on the other side of the vehicle. And you're going to hear the shot. It's horrific. You're going to be able to see Sergeant Baker as he runs for his life and collapses to the ground. And then you're going to hear 3 more shots. And then you'll see the face of Stephen Wiggins standing over to Sergeant Baker. Mr. Wiggins puts him in the car, the patrol cruiser that he arrived in. You're going to hear Stephen Wiggins impersonate Sergeant Baker on the radio. And Mr. Wiggins is going to drive to a field. And he's going to abandon the police cruiser, but not until he takes certain items. And like the prosecutor said, one of those items is the backup weapon of Sergeant Baker. Stephen Wiggins then sets the body on fire and flees that field. He's gone for a couple of days. Manhunt ensues, and the proof's going to show that the police, law enforcement were out. They come across Mr. Wiggins sitting on the side of a rural road. He's still armed with the two pistols. The one that he shot Sergeant Baker with in the backup one. But he peacefully surrenders. Goes into custody. And then you're going to get to see on a video Stephen Wiggins as he agrees to talk to law enforcement. Now, Stephen never denies shooting Sergeant Baker in that interaction. But he does lie about these things. And then you're going to hear him say, in response to a question from one of the TBI agents, like a dog. There's no question that Mr. Wiggins killed him. There will be no doubt in your mind, reasonable or otherwise, at the conclusion of this case, that is the facts. The only question that you as a jury may have to determine when you deliberate after hearing all the proof is whether or not it was premeditated. Whether or not in that moment Stephen Wiggins used reflection and judgment. The proof in this case is going to make you angry. It's going to make you angry at Stephen. And I know that because it made me angry. And it wasn't until I was able to learn more about Stephen, his life history, and his life course, that I was even able to begin to fathom how something like this could happen. You as jurors have such an important job to sit and listen. It's a difficult job. And I want to assure you, the defense does not intend to put forth witnesses in this portion of the case. Our intention is to cross-examine witnesses only to the extent necessary to complete a picture. You're going to see proof from Mr. Baker's widow, Ms. Lisa Baker. And I want to assure you, for her benefit, for the benefit of Sergeant Baker's family, fellow officers, and friends, that we intend to conduct our portion of this trial in a way that maintains dignity to Sergeant Baker's memory. Ever mindful of the tragic loss that all of those have suffered as a result of the attack. We spent a lot of time together last week, and I know that you are mindful individuals, deliberate individuals, thoughtful individuals. I have no question that you're going to be able to pay attention in this case, listen to the evidence, and render a just verdict. Thank you.
All right, State may call your first witness.
On state calls Lisa Baker.
Apparently we're having some difficulty with sound.
Difficulty with what?
Do you have-
You solemnly swear affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God.
Judge, may we begin?
You may.
Thank
Ms. Baker, I would just ask if you speak into that microphone and make sure everyone can hear you, all right?
Ms. Baker, will you state your full name for the court, please,
Lisa Schrock Baker,
and spell your first and last name?
Lisabaker.
Thank you. Ms. Baker, thank you for being here today. I know this is tough. Just a couple of background questions. Would you tell the ladies and gentlemen of the jury your relationship to Sergeant Daniel Scott Baker, please?
Yeah, he was my husband. I'm his widow.
In what year were you married?
2014.
Thank you. And can you tell us the age of Daniel when he was murdered?
32.
All right. And did you and Daniel have children together?
Yes, we have one daughter.
Okay. And how old is she?
She just turned 5 this week.
We actually had a birthday for her during the jury selection. Is that correct?
We did, yes.
Yeah. In Knoxville, Tennessee.
Yes.
How old was Meredith when her father was killed?
She was 22 months old.
22 months. In May of 2018, can you tell us where your family was living?
We lived here in Dixon County. We just bought our first house.
And your husband, Daniel Scott Baker, was a sergeant with the Dixon County Sheriff's Office?
Yes.
And do you remember what shift he was working in May of 2018?
He was on day shift.
Day shift. Do you have to get up pretty early to go to that?
Yes, usually, yes.
Okay. Do you remember seeing him in the morning of May 30th, 2018, the early morning hours?
Yes, I was up getting ready for work.
Okay. And can you tell the jury what happened that day?
That morning, he left when I was making my coffee, and he would always sneak a drink because he never wanted to drink coffee, but he liked to aggravate me. So I remember him doing that, and I remember him going in Meredith's room and telling her bye because he was in there for a minute, so I assume that's what he was doing. And then he left, and I finished getting ready for work, and I went to work.
And where were you employed at the time?
East Hills Dental.
Okay.
I'm a dental hygienist.
Dental hygienist. And you went to work that morning?
I did, yes.
And what happened then?
I tried to call him when I got to work like I would every morning just to say I made it and everything's good. So we started at 8 that day, and I got my first patient like I normally would.
And was that interrupted?
Yes, and one of the front desk girls came and said, "There's an officer here that needs to see you."
Okay. And what happened then?
Well, I excused myself from my patient, and then I head to the front lobby, and I remember opening the door to the lobby and seeing Bucky standing there, and the look on his face, I could tell something was wrong, but I didn't know what it was.
And you say Bucky, is he a Dixon County Sheriff's Office employee?
Yes, it's Kenny Monzon.
Kenny Monzon.
Mm-hmm.
Okay. So he had come to notify you?
Yes.
All right. And is that how you learned that your husband had been shot?
Yes, Bucky was the one who told me, but I didn't know that until after I'd gotten home.
Okay. Well, thank you for sharing that with us. Let me back up a little bit in time to a Christmas. Did you give a gift to Daniel of a weapon?
Yes, the first year we were together, I got him a Glock 357.
Okay. So, what did Daniel do with the Glock 357? Is that something?
It was to be used as a backup weapon.
Okay. And would you see him carry it on a daily basis as his backup weapon?
Yes, I would see him with it on several occasions. Sometimes it stayed in his police car, so I didn't see it every day, but I knew that he had it.
How did you know that he wanted a 357 as a backup weapon?
When there was something that Daniel wanted, then he made it known, and he would drop hints here and there to. I knew that's what he wanted. He even had it lined up at the sportsman's store. You know, if she comes in, this is the one I want. So.
Well, did you attempt to fool him that Christmas as to?
Yes, because I did that every year. But I would wrap something, and if it was small, I would wrap it in several sizes, boxes. And I even put bricks in this one to make it, to try to mask what it is.
And you actually have a video of surprising him with this gift, is that correct?
I do.
And without objection, we would like to play that video.
No objection.
All right.
Why? Wait, for the record, what did you say you think it is? No, you said. Whitney helped me with the packing.
Who did?
Whitney.
Holy crap, she paid the box there. Jesus Christ.
Don't cuss. I'm going to show this video to people. Now move the big box out of the way. It's a decoy.
Is that a gun?
Open it and see. I don't know. That was a little too easy to get in the box.
Holy crap. Oh my God.
Silence is probably not a good thing.
I don't know what to say.
Well, is that not what you wanted?
I don't know what to say.
Is that not what you wanted?
Yes.
Is it not? It's not the one you
I'm
wanted?
trying not to cry away. Take her camera off.
Is it fair to say that is what he wanted?
Yes. Yes.
Block 357.
Mm-hmm.
Move a copy of the video of the first exhibit of this trial.
Mark it as Exhibit 1.
Ms. Baker, if you could just spend a few more minutes with us, that would be great. I have a few photographs of your husband, Daniel, and of yourself with Daniel and Meredith that I would like to introduce. If you could identify those, please.
Okay.
If I could have the first one up, please. And can you identify this photograph?
Yes, that's Daniel fishing. He loved fishing.
Is it fair to say he was an outdoorsman?
Yes. Yes. We had to coordinate any activity around what season it was.
What season it was? Okay. Move that as Exhibit 2.
Exhibit 2.
And Ms. Baker, if you could identify the next photo, please.
Yeah, this is Daniel and Meredith at a birthday party.
And is the photograph that you're holding the same that we see on the screen?
Yes.
And I'll move that as Exhibit 3.
This is Exhibit 3.
Yeah, this is Daniel and Meredith having a tea party.
And does the photo you're holding match what we see on the screen?
Yes.
I'll move that as Exhibit 4.
And this is me and Daniel and Meredith.
Thank
She
you.
was getting on to us.
And does the photograph you're holding match what we see on the screen?
Yes.
Move that as Exhibit 5. And the final photograph.
The same. It's me and Meredith and Daniel.
And Meredith appears to be a little bit younger in this photograph. Is that correct?
Yes.
And does the photograph you're holding match what we see on the screen?
Yes.
I'll move that as Exhibit 6. And thank you for your testimony.
Thanks.
Any questions?
No, Your Honor.
Thank you, Ms. Davis. Ms. Baker, you may sit down. State may call your next witness.
Your Honor, state to call Linda Nichols.
Is that six exhibits?
Yes, sir.
Come forward, please, ma'am, and raise your right hand and be placed under oath.
Do you solemnly swear or affirm testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God? Yes, ma'am.
Signature, try to stick very close to the microphone.
Good morning.
Good morning.
If you would state your name for the court, please.
Linda Nichols.
And if you would spell your first and last name.
It's Linda, last name Nichols.
Thank you. Ms. Nichols, what do you do for a living?
I'm the director of the Cheatham County 911 Center.
Now, if you would, tell us about some prior experience you had that led to your position as director.
I've been in public safety for 33 years now. Started out as a line level dispatcher, worked up the ranks to director. Previously was in Dickson County and then moved to Cheatham County about 6 years ago as the director.
Now, if you would, discuss specific training that, as you said, a line level dispatcher goes through in order to perform their job.
So there's requirements set down by the state, training guidelines that each dispatcher has to do. You have to have basic telecommunicator, CPR, just missing children. There's all kinds of guidelines that they have down that you have to have as a dispatcher.
If you would, tell the jury some of the duties that a dispatcher conducts.
So on a day-to-day basis, they're taking 911 calls from citizens who are calling in with maybe medical emergencies, law enforcement, whatever type, the case may be. They're doing radio traffic from police, fire, and EMS units, answering admin phone lines.
Are there any, in what other ways may a dispatcher assist law enforcement?
They do, I guess you could call it kind of investigative work for them. They're running driver's license car tags, sending out teletypes, that type thing across the nationwide computer system.
What are teletypes?
It would be a message that they would send out, any type of situation maybe that law enforcement is working on, stolen cars, missing persons, that type of things.
You mentioned a nationwide computer system. Could you describe that, please?
NCIC, National Crime Information Center. It's run by the FBI. You run driver's license, car tags, criminal histories. You send out the teletypes through that. Just any type of investigative. It's only used for law enforcement purposes.
Now, do dispatchers in Cheatham County input that information themselves?
Yes, sir.
All right. If you would, I want to discuss the E911 system and how it actually works. If you would, walk us through what happens when someone calls to the 911 center.
So if someone calls in on 911, it's going to, obviously it rings there in the center. The dispatcher will answer the phone. We have it's called a CAD system, computer-aided dispatch, where they will create a complaint card that will have the information of where the person's calling from, the caller's name, their phone number, what type of call for service it is, and then they add notes to that complaint card as to what's going on with the call.
Is that done in every situation, in every call that comes in?
Yes, sir. If it's something that requires response by law enforcement, police, fire, if somebody calls in just asking a general question, then no, they wouldn't create one. But if they're requiring service from some of the emergency services, then yes, a card is made.
what happens with this card once the data is placed into the computer?
Once the call is completed, it's saved on a hard drive on our computer system.
Are calls recorded?
Yes, sir. Every call that comes into the center is recorded on a recorder. That's also saved to a hard drive on the computer. On the recorder.
So how are 911 calls, the recordings, matched up with the complaint card?
The call is recorded, and the complaint card is issued what they call a complaint number, a specific number to that incident, and then you can track them by that complaint number.
What, I guess, is the 911 center the only agency that uses that complaint number?
No, it would be specific to whatever, whether it be police, fire, or EMS, they would use that as their report number as well.
Now, you talked about how this data is stored. Are you able to recall the calls or the complaint cards?
Yes, sir. It's saved. We never delete the stuff. It's saved to a hard drive.
Are you required to store that information?
We are, yes, sir.
Is that by law?
Yes, sir.
Now, how are these complaint cards, how are they generated if you need to go pull them up later on down the road?
We just go into our CAD system and search for whatever information we have, whether it be by the day of the incident. Maybe we have the actual case number. We can search by that. We can search by address. Just there's all different ways that you can search to find the complaint.
Is that the same with the call recordings?
Pretty much by the day. We search that by the day.
Okay.
And the time.
Your Honor, let me approach the witness.
All right, you may.
Ms. Nichols, I'm going to ask you to review that document and tell us what it is.
This is a complaint card or CAD operation report is what the official title is. This is what would be filled out if somebody called in for service.
All right, let's talk about the specific report. If you would, tell the jury, or I guess walk them through the very top of the report that states call detail information.
Okay, so you can see it says call number. That's what I refer to as a complaint number. It's basically the year, the month, the day, and then at midnight it starts out at 001, and then as each call comes in, the numbers progress. The taker would be the dispatcher's name that actually took the complaint call or took the call. Position would be what console number that they were sitting at when they were logged into the computer to do this. The next over to the date and time would be, of course, the date and the time that the call came in. The next line down, the complaint, this one in particular says request an officer. Shows the priority on the call, how it was received, and this one it says 911. It could be, it could have like cell phone or admin line, and then it will give you the address, incident location. I'm sorry.
Go ahead.
And if there was an apartment involved, it would go across with the address.
So in this particular report, what day, what date and time was a call received to 911?
So this call was received on May 29th, 2018 at 5:39:38 in the morning.
And what was the location of the incident?
123 Liban Hills Road in Kingston Springs.
Are you familiar with that location?
Yes, sir.
And what's the name of that location?
It's Motel Midtown Inn and Suites. It's had a couple of different names. Cono Lodge.
And when you get an address for a location, such as 123 Liban Hills Road, what sort of information are the dispatchers able to call up in their system?
They can look back. It'll give you a little block that says previous calls, and you can look at every previous call that was at that address.
And in this particular case, looking at this report, how are you able to tell what happened in a call?
So if you look at the bottom under the narrative, this is notes that the dispatcher has added. Whatever the caller is telling them, they add that to the complaint card and save it, so that maybe another dispatcher is actually dispatching the call, then they can see the information that's being received.
Could you talk about that particular, what you just said, another dispatcher actually dispatching the call?
I'm sorry.
So I guess I'm asking, are you saying that one dispatcher may receive the call and another dispatcher?
Actually dispatch it to the police or fire or whoever.
And so when the dispatcher that took the call receives information, the dispatcher dispatching an officer, for instance, are they able to see that information?
Yes, sir.
And is that in real time?
Yes, sir.
And in this particular case, what was the nature of this call?
So this one was labeled as a request an officer.
And what was requested based on this report?
They wanted an officer to come out due to, it looks like maybe a domestic type situation.
Is a name given in this particular of the subject?
Yes, sir. The second note there, it says the person's name is Steve, unknown last name.
And in this particular case, I guess let's talk about the next line down from that. It's at 5:29, 2018 at 5:43 and 31 seconds in the morning. If you could, would you read for the jury what it says in this note?
Yes, sir. It says he just left in a brown 98 Saturn car. The tag was BRY310. Puppy paws on back window, got on interstate, possibly headed back towards Dixon.
And with information like this, just to be perfectly clear, where is that information coming from?
That's what the caller is telling the dispatcher.
And based on your knowledge of this particular matter, did one of your dispatchers put out a BOLO for this particular automobile?
Yes, sir. They called Dixon and gave it to him over the phone, and then I believe once the officers actually did the report, they sent out a teletype with the information across NCIC.
Your Honor, I asked to make this report the next exhibit in the trial.
Right, mark the exhibit 7, I think.
Yes, sir.
All right, Ms. Nichols, I'm going to ask that Mr. Etheridge play some audio for us, and then once it's done, I'll ask you a couple questions.
Your Honor, may we approach? You may. Does this need to be on the record?
Yes, Your Honor.
All right. Ladies and gentlemen, you've been told by me more than once that there may be times when I have to take something up outside your presence. This is going to be the first of those many that will occur during the trial. If you'll step across the hall with the bailiffs, then we'll take this matter up. So. All right, Mr. Wyatt, what exactly is this piece of evidence you're wanting to play?
Your Honor, this is a recording of the E911 call made by one of our upcoming witnesses, Ms. Lear Bond Sr., who is clerk at the Midtown Inn and Suites. In that audio, you can hear Ms. Bond Sr. making the phone call. You do hear Ms. Castro Miles in the background kind of narrating what happened. And then at a certain point, Ms. Castro Miles gets on the call, gives a description that Mr. Wiggins has left in her car, the brown Saturn. She gives a license plate to E911, which then is, Ms. Nichols testified, put into a BOLO.
All right. And the purpose of playing the video, I mean, this witness has identified that this was a plate number of the car that was reported stolen. She's already got that in the record, correct?
Yes.
All right. So what is the purpose in playing the actual recording? I'm just wanting to get it into the record.
So the jury's fully aware of what occurred that morning so that they can see how this progressed. In particular, it'll later go to show how Mr. Wiggins, through other witnesses, how he left, the situations under which he left, and then when he eventually came back and picked her up. So that the state can show that the car was reported stolen, that led down the series of events that lead us here to today.
All right, let me hear from the defense.
Your Honor, to play the audio itself is absolutely improper. I mean, it's any statement by Ms. Castro-Miles is hearsay. It's testimonial in nature. She was going to make allegations against Mr. Wiggins about the dynamics of whatever dispute may or may not have been going on, or what was going on inside that room that night. Has no bearing on this trial whatsoever. Has no bearing on what the purpose of the 911 call is intended for, is that there was a bolo and a report of a stolen vehicle. That's been established and can be established through the report that's already been put into evidence. It would be unduly prejudicial to Mr. Wiggins to try to put him in a position to have to try to litigate the veracity of what Ms. Castro-Miles is saying when she will at no time be a part of this proceeding. Your Honors, and again, it's not relevant. So it's unduly prejudicial. It's not legally or logically relevant. We'd ask that the audio itself be excluded.
In response, Your Honor, this falls under the business record exception for the hearsay rule, as well as there's excited utterances that take place. Based on Your Honor's prior rulings regarding the theft of the vehicle and the possession of a firearm on that morning, where the state's allowed to put in evidence of those two issues, the state redacted statements made between the caller and the dispatcher in reference to the alleged assault that occurred. So that information has been stricken out prior to Your Honor's prior ruling. This ultimately paints the whole picture.
If I'm understanding correctly, then this recording that you have has already been redacted to deal with that particular situation.
Yes.
Then let's play the recording. It's not very lengthy. Let's play the recording, let it be demonstrated, and then we'll determine whether or not it presents an issue.
Hey, can you send the police to Midtown Suites? I have a guy in one of the rooms here. He's got a gun.
Okay, what's he threatening to do? Or?
Well, he just sued this girl out with no clothes on. I got her in the office here.
And he's in the room. What kind of gun does he have?
What kind of gun is it? She doesn't know.
What was he doing?
Are they close by? Huh?
Were they drinking, or what were they doing that started this?
Have y'all been drinking? No.
Okay, what were they doing that started this?
I don't know, sir. What started it? I don't know. He just lost his mind. She said he just lost his mind. Is he doing drugs? No, no drugs, no alcohol.
Okay, what room is he in?
What room is it? 121.
All right, hang on 1 second. Don't hang up.
He's down here naked in the office. I had to throw a towel on her.
Yeah, hang on 1 second, okay?
Thank you.
All right.
Yeah, I was to the bathroom next door and I was first y'all. I thought you were.
Is he her boyfriend or her husband or?
Kind of, sort of.
Okay, what's his name?
She doesn't know his last name. I can't think of it. She's pretty upset.
Yeah, I hear it. And what was your name?
My name is Lear. I work the third shift. Seems like I'm always calling you.
Okay, that's fine. And she wasn't hurt or anything. She doesn't need an ambulance.
You need an ambulance, honey? No.
Okay. And what's your callback number?
It is, look it up. It is 615-952-2900.
952-2900.
Yes, sir. She just said he left. What's he in her car? It's a 98. Here, hold on a minute. It's a 98 Saturn Series license plate BRY 310.
Okay. You said it's a 98 Saturn?
Yeah, he just got on the interstate. He's probably heading towards Dixon.
Okay. What color is it, ma'am?
It's brown, and it's got puppy paws on the driver's side back window, and live love and pet on the passenger side rear window, and it's got a California flag and the sugar skull on the middle of the windshield.
So you think you're possibly headed back towards Dixon?
Yeah, probably. I'm not sure. She has all my stuff in the car.
Okay. And you don't know his last name?
I can't think of it at the moment.
Okay. Wait in the office with the lady. We got a couple officers on the way to pick the job. If he shows back up, just call us back, okay?
Okay.
All right, thanks.
My concern, Mr. White, is that essentially, I understand it may be an excited utterance exception, but we're talking about a Sixth Amendment right of confrontation, and we have this statement by the co-defendant whose case has been severed for the very reason that we're, dealing with and trying to ensure that there's not any Sixth Amendment right of confrontation. So it seemed to me that it's not necessary to play this audio. I assume you have other witnesses who can. I think we even have pretrial hearings where the officer who responded to the scene testified, but it seems to me that it's already been established that the vehicle was reported stolen. If that's the only importance of the audio, then it was, I think erring on the side of caution would mean that we need to exclude the audio. There's no objection, there's no contention by the defense that it was not reported stolen. So I think that otherwise we've got an issue with her coming in making accusations. And, obviously her voice conveys emotion and upset that may go to the other crimes and other bad acts issues. So I think we need to exclude the video and let her go ahead and testify. She's testified that already the vehicle was reported stolen. Other witnesses can testify about the facts of the event, but otherwise can avoid some of the issues by this recording.
Very well.
So I sustain the defendant's objection. Now, at this point, you have other questions for this witness? I wanted to do it before we bring the jury in, so I just was going to find out for sure. But normally, they're going to take the jury to lunch today and away from the scene, so we need to make sure that we are giving enough time for them. Never mind.
Question. You asked about questions, Your Honor. No, I have no further questions.
Are you going to have questions for this witness?
No, Your Honor.
What time are we going to bring them through
They were working on getting it here now.
After this witness, does the state have additional short witness, or is it going to be a more lengthy one?
Those are all going to be 15 to 20 minutes.
Well, if you have one that can be 15 to 20 minutes, that'd probably work out pretty well. Let's go ahead and bring the jury in. So. Thank you. Ladies and gentlemen, as I explained to you in the opening instructions I gave you, from time to time I'm going to have to consider and make rulings on certain issues, and the responsibility for that falls to me and no one else. I have ruled that there's really no need for the playing of this audio because it raises some issues that I have already previously ruled on. So I have ordered that the audio is not going to be played. Don't try to guess what that audio may have said, anything on it. This witness has identified that the vehicle that we're talking about was reported stolen, and during that phone call, the record of that 911 call is being introduced to substantiate that. There's no need for us to listen to the audio recording to further establish that. So thank you.
Thank you, Your Honor. Thank you, Ms. Nichols. I'll pass the witness.
No questions.
Thank you, Ms. Nichols. You may be released, and State may call your next witness. Thank you.
On the state calls Ms. Lear Von Senior.
I'm sorry, repeat that.
Ms. Lear Von Senior.
We lost signal to the screen, but I assume that's Jeff. That's his name. You got that? My expectation is after the following of this witness, we'll probably break for lunch.
Yes, Your Honor.
You may. On or off? I have a little cubbyhole back here that I can go to avoid trying to whisper, since I can't hear everything as well as I'd like to. So when we go back there in the corner, it's just to talk about something that's off the record. It's a procedural issue, nothing that you need to necessarily worry about, okay?
Stand right here, face the clerk, raise your right hand.
You solemnly swear affirm the testimony you give in this case be the truth, the whole truth, nothing but the truth, so help you God?
I do.
Sit in this chair right here, speak directly into the microphone.
And we're going to ask you to move up as closely to that microphone as you can so that we can be sure to hear and understand everything you have to say, please.
All right, can you hear me?
Yes, ma'am.
For the record, Ms. Bonsignor, could you please say your first name and spell your last name as well?
My first name is Lear, and my last name is Bonsignor, Bonsignor.
Oh, thank you. And in 2018, Ms. Bonsignor, how were you employed?
I worked the third shift at the Midtown Inn.
Okay. And where is the Midtown Inn and Suites?
Kingston Springs, Logan Hills Road.
Okay. Is that in Cheatham County?
Yes, ma'am.
Okay. What shift were you working then?
Third shift.
And do you remember approximately what kind of hours that might have been at the time?
For a while, it was a 16-hour thing, and then I think we switched to like 11 o'clock till 8 in the morning.
Okay. Were you working at the Midtown Inn and Suites on May the 29th, 2018 in the early mornings?
Yes, ma'am.
And do you remember an incident that happened, somebody come to the office that stood out in your memory?
I do.
Could you explain to the court what you observed?
I had a young woman come to the office, and she didn't have any clothes on,
and she was upset, crying.
Did she require police assistance?
Well, I thought she did.
Did you make a 911 call?
I did.
All right. Is there video footage at 123 Liebman Hills Road at the Midtown Inn and Suites?
Yes, ma'am, there is.
Okay. And could you describe for the jurors what the hotel consists of? Is it 1 stories, 2 stories?
It's 2 stories. I think it has 25, 26 rooms.
And there's surveillance cameras that are there?
Yes, ma'am.
Where are the surveillance cameras focused?
On the rooms.
Are they? Is it
and the office.
Is it outside in the parking lot?
Yes, ma'am.
I'm going to put a still up. Do you recognize what this is an image of?
I do. It's the motel.
Okay. And it says down at the bottom, camera 8. Are you familiar with the view of this?
Yes, ma'am, I am.
Okay. And could you explain where this camera is sitting in relationship to roadways and rooms?
It is sitting in the trees trying to show the parking lot and the rooms.
Okay. Is it facing outwards to the road that leads into the hotel?
Yes, ma'am.
On the right-hand side, the building that's there, is that the hotel? On the right-hand side of the video?
Okay, yes, ma'am.
Yeah. Are those the hotel rooms?
Yes, ma'am.
Up in the right-hand corner of the screen, do you see a date and a timestamp?
I do. 5:49
a.m.?
a.m.
And is that on May the 29th, 2018?
Yes, ma'am.
Okay. So have you reviewed this video? Is it an accurate depiction of the area at the time?
Certainly is, yes.
Your Honor, I believe based on a conference, we need to have a jury out at this point.
All right, round 2. Ladies and gentlemen, if you'll step across the way. The reason we're doing this is because I've made some preliminary rulings and motions before this court, before we started the trial, and I just need to make sure that this video is going to reflect my ruling, so that's why we're doing it. Thank you. All right, with the jury out, we're going to play this recording to make sure, is that correct?
Yes, Your Honor, and we have several, these are small snippets of a much larger video, so if we could just walk through all of those, I believe.
Let's go through them all so that we don't
Okay.
let the jury have to get out any more than we have to.
Yes. Yes, please.
Is there a way to dim the lights even more? Is that, okay, that's fine. Is there a sound to this?
No, Your Honor. No, and that's the first video, Your Honor.
All right.
And this is the second video. And that's the conclusion of the second video, Your Honor. This is the third video. And that's the end of the third video, Your Honor. And this is the fourth video. And that's the end of the fourth video. And this is the fifth video. And that's the end of the fifth video. And that is a still photo that we anticipate from one of the videos. And that's it.
That it?
That is, Your Honor.
Anything from the defense outside the presence of the jury?
Yes. Your Honor, we renew objection to video number 1. Video 1 is the video, as Your Honor recalls, that was played that depicted what prosecution purports to be Ms. Castro-Miles walking naked from the room to some other location. Your Honor, several reasons. One, it's not relevant to this proceeding. What condition she was in when she made appearance into the hotel lobby and to meet with the hotel personnel and called 911, because that triggers the next concern, which is 404B. This is getting into the substance of other act evidence, because essentially it puts facts into evidence regarding what state Ms. Castro-Miles was in, her demeanor, all those things that were going on, which are in no way relevant to the facts that the state is intending to prove, which is the car was was reported stolen, and that essentially that Mr. Wiggins gets in the car and takes the car. That's video 2. I think that's a different story if they're trying to prove that he took the car, so he had the car. But video 1 and getting into the substance and digging down into whatever the circumstances were that led to that, I think it's our position, are irrelevant, and they're unduly prejudicial, and again, it triggers 404B, and again, it leads to an issue where I think the jury's confused.
I had previously issued a ruling on this that I found by clear and convincing evidence that this situation and these facts were in fact clear and convincing. It appeared to me to be relevant to the whole story as the reason that the encounter between the victim and the defendant and co-defendant on May 30th, when the car was still listed as stolen. That was my original ruling. I see no reason to change that. I note the defense's objection to it. I don't see anything in particular in the video that would indicate to me that there was any reason why there would be anything. Whatever the first video was very grainy footage, and I don't believe it to be anything that would be prejudicial per se. All right. Anything before we bring the jury back?
So for clarification, Your Honor, all 5 of those videos fall under your ruling.
Correct. All 5 videos will be allowed as evidence.
Thank you, Your Honor.
Bring the jury up.
And the still photo, Your Honor, as well. And the still photo that we showed as well.
Thank you, ladies and gentlemen, again for your patience. We're going to break for lunch after this particular witness, but they're going to play some videos for you and some photographs that will be demonstrated on the screen.
Your Honor, Ms. Bonsignor, to review, on May the 29th, 2018, early in the morning, you previously stated that a woman showed up to the office and she was not clothed. Upon learning that she was not clothed, did you make any phone calls?
I called the police.
Okay. And do you know if did the police respond to 123 Liebman Hills Road?
Yes.
Okay. And we had previously shown a still image of a video that you had described as the outside of the Midtown Inn and Suites. Is that the?
Yes, ma'am.
Okay. If we could please play that video now. Now, Ms. Bonsignor, do you recognize what that is a surveillance video of? Mm-hmm. What is it?
Ms. Castro.
Where's the office located?
You cross that highway divider thing there, and it's about 500 feet.
Is she moving towards the direction of where you were in the office?
Yes, ma'am.
Okay. If we could play the next. Ms. Bonsignor, at the top, does it have a date and time again?
5/29/2018, 5:35 a.m.
Okay. If we could play that, please.
5:52. Sorry.
And if I could ask to pause the video there. Ms. Bonsignor, what were you observing in this video?
The defendant leaving?
And did he head towards an automobile?
Yes.
Can you tell if the door was opened?
I think it was in the beginning.
Did he open the car door?
I think so, yes.
If you could rewind that, please, so you can play
Let's
that.
see. Looks like he did.
So he did open the car door? Okay. If we can move on to the next video, please. And Ms. Bonsignor, do you recognize again what this is the same camera?
Yes.
And can you read the date and the time, please?
5/29/2018, 7:53:20 a.m.
Okay. And so this is about 2 hours after the last video. Okay. And the next video, please. Ms. Monsignor, can you again identify what this video is?
It is the defendant leaving the room.
No, identify the date and
Oh,
the
I'm sorry,
time and stuff, please.
5/29/2018, 7:58:48 a.m.
Okay, so this is a few minutes after the previous video. Bonsignor, there appeared to be another person, a new person in this film that was wearing white. Who was that?
Me.
That was you. And where were you walking to?
I had walked to the room because I thought that her brother was coming to pick her up. That's what I was told.
And when you walked down there, can you describe who you encountered?
The defendant.
And can you describe the conversation that you had with him?
I didn't know he was the defendant at the time, but I thought it was the brother, and I just said, "Oh, you're moving out. Well, take care. Everybody do good. Good luck."
Okay. At any time, did Mr. Wiggins identify himself at that point as Mr. Wiggins?
We need you to make a verbal response, ma'am.
Oh, I'm sorry,
that's
sir.
fine.
No.
Okay. And the last video, please. And Ms. Bonsignor, if you could read the date and the time of this video, please.
5/29/2018, 8:01:35 a.m.
And again, that's just a few minutes after your encounter with him.
Yes.
Okay, thank you. Your Honor, we would move all 5 of these videos as collective exhibit number 9.
All right, collective exhibit 9. Exhibit 9, what's that?
Just make it exhibit 9. It would be exhibit 8, scattered with 7.
Oh, I'm sorry, Your Honor.
She hasn't entered that yet.
I wonder if I could
All right.
approach the witness.
We'll mark this as exhibit 8, the video for exhibit 8, the still photograph that we're about to deal with is next.
Ms. Bonsignor, I painted you a photo. Is that the same photo that's up on the screen right now?
Yes.
And is that a still from one of the videos that we had just looked at?
Yes.
Thank you. And we'll move this as the next exhibit.
This will be marked as exhibit 9.
Now, Ms. Bonsignor, you said that when you went back down to the hotel room to check, you believed that her, Ms. Castromel's brother was there. Why did you believe that her brother was coming?
Because a man had made a phone call to the office inquiring about Miss Castro, if she was okay, if the police were still there.
All right. Nothing further on.
Any questions?
No questions.
Thank you, ma'am. You may be released.
Thank you, Judge.
Thank you. All right, ladies and gentlemen, at this point, I think it's appropriate to us break for lunch. So we're going to go ahead. I think they're bringing your lunch in for you, so we will allow you to go to the jury room and have lunch. It is 12:25. Let's break for lunch until 1:30. 1:30. All right. All right. Ladies and gentlemen, let me just remind you again that although we've started the evidence and you're hearing some of this testimony, your duty is not to discuss this case or what you just watched. All right. Avoid any discussion about it till we get to the end. Thank you.